Passing off is a tort which is based on the principle that no man is entitled to steal another's trade by deceit. That's a form of words that was used by Lord Oliver of Aylmerton in Reckitt and Coleman against Borden in the House of Lords, a case that we'll be talking about much more during the course of this presentation. Passing off is a common law action. It's made by the judges, there's no statute, and judges can adapt the rules to new situations, as they've done with things like domain names, character merchandising, and celebrity endorsement. The downside of it being judge-made law is that the decisions of the courts can sometimes be difficult to reconcile, and it may be that a case has gone one way simply because the losing party didn't prepare its case well enough. So there are inconsistencies in the law, and we'll see some of those over the next few minutes. It's a long-established form of action. It's been around for a long time, and to a large extent it's been replaced by being able to register trademarks, and the registration of trademarks created an easily protected piece of property which was useful for businesses as the consumer society began to emerge in the 19th century. But the action for passing off hasn't gone away, and actually it hasn't lost its usefulness. There are two types of passing off, one of which is a relatively modern invention, but the classical sort of passing off involves a misrepresentation about the source of goods or services, and in that sense it's very closely related to trademark law. So it's sometimes said to protect unregistered trademarks. That's by no means the full extent of the passing off action, and just because a trademark is registered doesn't mean to say it can't also be the subject of a passing off action, as we'll see. But in a sense, unregistered trademarks are the subject matter of passing off, but strictly speaking it protects business reputation and goodwill. Goodwill is really the main focus of attention of the passing off action, as we'll see. More recently there have emerged various species of extended passing off claims, for example based on shared goodwill, and producers who share the reputation or goodwill in a name like champagne have been very enthusiastic litigants using passing off action to protect that reputation. The emergence of character merchandising has also caused an extension of the basic idea of passing off. Celebrity endorsements likewise, and there are some cases on reverse passing off, or what's become known as reverse passing off, which show that it can work in the opposite direction from the classical situation too. This has led some commentators to describe it as a protean tort. And when you come across a word like protean, you need to find out what that means. At least I feel the need to do so, and it means that it is tending or able to change frequently or easily, and that sums up the way that passing off law is developing very neatly. So it's an anachronism. It's been around for a long time, and trademark registration should largely have replaced it, but it's a very useful anachronism. It's much less important now since the Trademarks Act 1994, because that legislation widened the definition of infringement. Before then it was almost inevitably the case that you would sue for trademark infringement and passing off at the same time. That's no longer quite as necessary, although it hasn't gone away entirely. So if a trademark hasn't been registered, if it's unregistered for that reason, just because the owner hasn't got round to doing it, or hasn't had enough money to do it, or hasn't thought to do it, unregistered trademarks can be protected by passing off action, but also signs that cannot be registered as trademarks can be protected. It's an alternative for trademark owners whose registration could be invalid or revoked, or simply hasn't been made at all. Redaway and Banham, classic case on classical passing off from the 19th century involved a product called camel hair belting, and it was basically belts made from camel hair. So it wouldn't function very well as a trademark, far too descriptive, but it had acquired enough of a goodwill for a passing off action to lie to protect it. Reckitt and Coleman and Borden, which I've mentioned already, is known as the Jif lemon case because that's the product that was involved. Lemon juice sold in a plastic lemon-shaped container. It wouldn't have been registrable as a trademark when the litigation took place. The law was changed in that respect too as a result of the 1994 Act. So passing off was all that Reckitt and Coleman were able to rely on. The passing off action also still gives supplementary protection to registered trademarks, which can be quite important. A claim for passing off can succeed even where there's no infringement. United Biscuits against Asda illustrates this, where there was no infringement of United Biscuits' Penguin trademark for chocolate biscuits, when Asda introduced a line called Puffin for chocolate biscuits. There was no infringement because the judge reckoned that the public could tell one seabird from another, but it was decided that passing off was taking place. On the other hand, in another case involving Asda, they didn't pass off when they used various insignia that looked rather like those used by Specsavers, but they did infringe Specsavers trademarks. There are two cases you can look at to get a basic statement of what amounts to a passing off action. The earlier one is known as the Advocat case, Irvin Warning against John Townend and Sons, Hull Limited, and it involved, as the name suggests, the sticky drink which has been made in Holland for a long time, and the defendants had introduced a product that they called Keeling's Old English Advocat, which is a bit of a contradiction in terms. And in that case, different judges in the House of Lords had different formulations, but the persuasive one was that put forward by Lord Diplock, who said that for a passing off action to lie, there must be a misrepresentation. It must be made by a trader in the course of trade. It must be made to the defendant's prospective customers or ultimate consumers. It must be calculated, in the sense that it's a foreseeable result, calculated to injure the business of another, and it must cause actual damage to the claimant's goodwill or be likely to do so. The second of those 5 requirements, that the misrepresentation be made by a trader in the course of trade, is quite important because it narrows the scope of what might amount to passing off. What goes on outside a trading context won't be passing off. It might be other things that can be dealt with by law, but a passing off action won't lie in those situations. It's worth mentioning that Advocat was an early instance of an extended passing off action because warnings were taking action not to protect the name of their product or their trade name, but to protect the generic name which applied to the product which they made and which a number of other people also made. But that doesn't alter the fact that that's a valid formulation of what needs to be present for a passing off action to lie. Lord Diplock then did go on to warn against what he called the logical fallacy of the undistributed middle, by which he meant that you can have those 5 elements present, but it doesn't necessarily mean that a passing off is taking place. So they're essential for there to be a passing off, but just because they're all there doesn't mean that there is a passing off. About 10 years later, Lord Oliver set out a 3-stage test in the Jif Lemon case, and this is known usually as the classic trinity. First of all, he said the plaintiff must establish a reputational goodwill attached to the goods or services supplied. Secondly, he said there must be a misrepresentation by the defendant which is likely to lead the public to believe that the goods or services which the defendant's offering are actually the claimant's or plaintiff's goods or services. And finally, there must be resultant damage to the claimant's goodwill or reputation, or a likelihood of such damage arising from the belief which is caused by the misrepresentation. It's Lord Oliver's classic trinity which is usually the starting point for judgments on passing off cases, so that's the analysis that I'm going to follow in the rest of this talk. First of all, there's a requirement that the plaintiff must have sufficient goodwill in the get-up of the goods or services. That's the, well, sometimes referred to as the trade dress as well. It's the way that the goods are packaged and identified, and all the signs that are attached to them to indicate where they've come from and to attract consumers to buy them. And a similar sort of thing applies to services as well, except that you don't package up services, you advertise them in other ways. So the basis of all passing off actions is the protection of goodwill, and if there is no goodwill to protect, a passing off action won't lie. What do we mean by goodwill? There's a definition by Lord Macnaghten in a 1901 case, a tax case, Inland Revenue Commissioners against Mullock and Company's Margarine, where he called it the attractive force that brings in custom. Well, there are different ways of looking at goodwill, but that's a very useful, workable legal definition. It's up to the claimant to establish that they've got goodwill or reputation in whatever trade symbol it is that they're trying to protect by a passing off action. The goodwill or reputation could be analysed as the difference between the value of a business and the sum total of the business's assets less its liabilities. That's an accountant's view of what amounts to goodwill, and it too has got a certain amount of value as part of our analysis, but it's not really what we're looking for from a purely legal perspective. So goodwill attaches to the business. It's an asset of the business. It's a piece of property, so the cases tell us. And when the business becomes insolvent or it's wound up in some way, when it's permanently wound up, the goodwill disappears. However, there are cases which explore when a business can truly be said to have been completely wound up, and Adlib against Granville in 1972 was a classic case of the discontinuation of a business not causing the goodwill to be lost because there was no intention to close the business permanently. The claimant was still trying to reopen his nightclub, and the reason it had been closed in the first place wasn't because he made a deliberate decision to do so, but he got too many complaints about the noise it was making. Goodwill is local in character. It may spread throughout the whole of the United Kingdom. It may be bigger than that, although it's not going to be actionable if it lies outside the United Kingdom. Or it may be more localised. It may apply only in a particular locality. So goodwill will be limited geographically, and will also be limited in time. It can only be created by dealings with members of the general public. That's a principle which was set out in 1984 in a case involving Budweiser, Anheuser-Busch against Budojoviski Budvar. There are many cases involving the Budweiser trademark, one way or another, trademark infringement cases, passing off cases, and indeed geographical indication cases as well, in the UK and in many other jurisdictions. And in one of the cases that came before the Court of Appeal in the 2000s, Lord Justice Jacob described this dispute as 100 years' war. In fact, the litigation had indeed been going on for 100 years by the time that case came before the court, so it's probably now more like 110 years. It's possible for sufficient goodwill to be generated by activities that take place before the product is launched, before the public has got any opportunity of buying it, but this is one of those areas where the authorities really aren't very satisfactory. And there are problems arising from the fact that so many of these cases are decided at a very interlocutory stage. At an interlocutory stage on things like applications for interim injunctions, and on applications to strike out the litigation. So you may well get a judge saying, well, I'm not going to strike this out because I think the claimants have got a good arguable case. But that's not to say that the law supports the claimant's arguments. They might not be able to prove that that's actually the situation, and much will turn in a passing off action on proving that they have the goodwill and that misrepresentation is taking place. And without a full trial, you don't get to the bottom of those very fact-based issues. So BBC against Talbot is an instance of sufficient goodwill being generated through pre-launch activities, with the product involved, an information service called Carfax being mentioned on Top Gear, which I think was a fairly new television show in those days. So it's not beyond the realms of possibility that goodwill can be generated without actually carrying on any trade, without actually selling any products or services, but the cases tell us that it's unlikely it'll be a special case if it does arise. Businesses can have a reputation, but without having goodwill. They convert the reputation into goodwill by having a trade presence in the jurisdiction, and of course the goodwill is limited by the extent of the jurisdiction as well. So there's got to be a business or trading presence, generally speaking. But again, the cases are inconsistent and often hard to reconcile. So the Budweiser case, Anheuser-Busch's claim failed because they had only been selling their beer in the UK on US Air Force bases. It wasn't available to the general public. So the Czechs won that round of the 100 Years' War. On the other hand, Maxims and Dye establishes that a spillover reputation can suffice, and that will happen if members of the public in the UK are familiar with a restaurant in Paris and are in the habit, or at least some of them might be occasionally in the habit, of phoning up to book a table there. Athlete's Foot Marketing Associates turned on the fact that there was no business in the UK, but there were customers who had bought from the American outlets of the company. So the mere fact that they hadn't opened any shops here didn't mean that they had nothing that they could protect, and they won on that basis. My Kind of Bones against Dr. Pepper's Stove Limited indicates that a lack of customers isn't the only test, but again it's important to note that this was an application to strike out only, so there was no consideration of all the facts of the case, and the judge didn't express himself to be particularly convinced that the claimant was going to be able to succeed. Promotional work will suffice, as in BBC against Talbot. Bernardin against Pavilion Properties Limited, that's the Crazy Horse Saloon case involving the Paris nightclub. Advertising had taken place in the UK, but that was as far as it went. They didn't have an establishment here, and on that basis they failed to get the injunction that they wanted. The Cipriani case involved two people who were both members of the same family, but the hotel in Venice which carried the name had been sold off to another party, and the branch of the family which was then trading in London, running a bar, argued that they were entitled to do so because they were running a bar under the same name in Venice. Still, it was held that they couldn't do that they couldn't continue to use the family name, and actually what this indicates above all else is that the agreement by which they sold the original business was rather defective. But the Court of Appeal in that case took the opportunity to speculate a little bit about the impact of the internet and the fact that you can now so easily book a table on the internet in a restaurant in a foreign country, and Lord Justice Lloyd wondered whether in the internet age it wasn't appropriate to start rethinking these things, although he did say that the case before him didn't give him an opportunity to do that. Waterman against CBS is the Hit Factory case. It involved a recording studio. CBS had a recording studio under that name, or were running one under that name in New York, planned to move to the UK. Pete Waterman took action to try and stop them on the basis that he was already using the name, but actually he failed to establish sufficient distinctiveness in the name. So the fact that CBS weren't using it in the UK wasn't the important thing. In that case, it was the fact that the claimant's case turned out not to be sufficiently strong to decide that, and the main interest of that case is that it provided the court with an opportunity to review a number of cases in this field. The Conagra case, an Australian case, is important because in there the court held that consumer knowledge and damage to the reputation of the claimant was sufficient. So they didn't actually look for goodwill, and very often in passing off cases the Australian courts have led the way and the English courts have followed later, so that might become quite significant in the future. But at the moment we have the latest word, which is the Starbucks case, and it's not that Starbucks, it's another Starbucks company. It was, as Mr. Justice Arnold explained in his judgment, at first instance it was a case in which it was a company that was formed from the proceeds of sale of a business called Star. So the owner of that business had made a lot of bucks, so they put the money into a new business and they called it Starbucks, and what the coffee people thought of that history doesn't record. They sued British Sky Broadcasting, which interestingly is part of the same empire, the Murdoch Empire, which had bought the original Star business from the claimants. And it's a case that went all the way to the Supreme Court. So the fact that we have a Supreme Court judgment here is very significant. The claimants were the defendants were broadcasting a TV channel, or the claimants were broadcasting a TV channel rather over the internet in Chinese, and it was viewed by a number of Chinese speaking people in the UK, so there was definitely an audience for it here, but there were no subscribers. They weren't doing business with anybody here, and the court said, in the present state of the law, internet exposure in the UK is not enough. The mere fact that you've got people accessing the service over the internet doesn't establish goodwill and get you off the ground for a passing off action. So that seems like a further rejection of Lord Justice Lloyd's speculation in the Cipriani case that perhaps in the internet age we needed to revisit these things. The Supreme Court wasn't prepared to do that. How long goodwill will last is a question of fact in each case. It's a heavily fact-based area of law in general, and if the claimant closes the business with no intention to reopen it, goodwill will be extinguished. I've already explained that basic principle. The Adlib Club case, where the nightclub closed because of noise problems, provides an illustration of a situation where goodwill can carry on after a business is closed. On the other hand, Star Industrial Company against Yap Kui Kor, which is not the same Star as was involved in Starbucks, shows us that when the goodwill is assigned to a third party, it's well and truly gone, and the original owner of the goodwill can't then take action for passing off. A rather extreme case of goodwill surviving for a long time after the trademark was used is the Jules Rimet case, which involved goodwill in the 1966 World Cup mascot World Cup Willie that was used by the UK authorities when they organised the World Cup here. And of course, since England won the World Cup in 1966, this has got a special historical significance, which may perhaps account for the fact that the court held that goodwill had indeed survived, in spite of the fact that the Football Association hadn't used it for decades. It was simply because they didn't have the opportunity to use it. Had they been organising the World Cup again, they might well have used it, so there was no intention to allow the goodwill in World Cup Willie to lapse altogether. The reputation that a business must have must be a business reputation to be protected by a passing off action, or it must be goodwill. Whether business reputation and goodwill are different things is probably not an important point, but reputation, mere reputation, is converted into goodwill by doing business, by selling goods or services to customers. So what you're trying to protect by a passing off action might be a brand name, in which case it must have been used to indicate the commercial origin of the goods. That's basically what brand names are all about. It must be distinctive of the business, and it can acquire secondary meaning to make it distinctive. That was illustrated by the camel hair belting case, Redaway and Banham, all those years ago. There's no need for the reputation to belong exclusively to one claimant. It can be shared, and it can be owned by more than one business simultaneously. There are examples of shared reputation from a number of cases where champagne houses, for example, have taken action to protect the word champagne. Bollinger against Costa Brava Wine Company, that's known as the Spanish champagne case. The Choco Suisse case, you can imagine, easily involved chocolates, and Cadbury describing some of their products as Swiss chocolate. The Consorzio di Prosciutto di Parma, the Parma ham case, where Marks and Spencer's was sued for calling their product Parma ham, where it wasn't. I think it originated from the Parma area, but they bought it whole and sliced it up somewhere else, and the fact that it was sliced elsewhere meant that it didn't meet the requirements to be described as Parma ham. Finally, the Diageo case, which involved the name vodka for the spirit, and the defendants in that case, Intercontinental Brands, were producing a product which they called Vodcat. It didn't contain vodka, and it was nothing like vodka, and Diageo sued for passing off on the basis that this was a misrepresentation, and they had a shared reputation with other vodka manufacturers. Two businesses which are independent of each other could start using the same name at the same time and acquire a simultaneous reputation. That's basically the situation that's arisen in Budweiser, with the Americans and the Czechs sharing or having a simultaneous reputation, not sharing it by any stretch of the imagination. And it all stems from the fact that the Czechs, for some reason, told Anheuser-Busch that they were welcome to use their name in the United States. It shows that trade can and other circumstances can develop in ways that you don't foresee at the time that you liberally grant permission like that. You can also have two businesses using a sign that come from a single source, and there's a case involving two McAlpine companies, Sir Robert McAlpine against Alfred McAlpine. The same family set up both businesses. Very often you find that businesses have been split up and gone in different ways and have still got the same name, so that's a situation where you can have a simultaneous reputation. Nobody is passing themselves off as the other one. So that's trade reputation, goodwill, which is the essential subject matter of passing off action. The substance of the action is to deal with a misrepresentation. The misrepresentation, as we've seen, must be made by a trader in the course of trade, and it will commonly arise where the defendant uses some sort of indicia which are identical with or similar to the indicia used by the complainant. That was the case in the Jif Lemon case, where Borden were also using a plastic lemon-shaped container. As it happens, it was bigger and it had a red label on it instead of a green label, but neither of those differences cut any ice in the outcome of the case, which Reckitt and Coleman won handsomely. The misrepresentation may comprise the defendant substituting another product for that of the claimant. So if you ask for one manufacturer's goods, you ask for Coke and you're served Pepsi, for example, that could be a passing off. It'll also likely be a trademark infringement, and there might well be trade descriptions type offences committed, but there's no reason why that sort of action shouldn't be brought under the heading of passing off. It can also be the case that the defendant supplies lower quality products, even though they are genuinely made by the manufacturer, by the claimant. And that was what happened in Spalding and Gamage. That involved a sale of footballs. They were made by the claimants, but they were seconds. and the defendants, when they sold them, let the customers believe or misrepresented them as being first quality footballs. So that too was passing off. So the misrepresentation may be express or implied, it may be by words or conduct, and it may be fraudulent or innocent. Doesn't matter whether it's fraudulent. An innocent misrepresentation will still be actionable, and the fact that it's innocent will probably be reflected in the award of damages rather than liability. The misrepresentation has got to have an effect on the minds of consumers. It must make them believe that in some way the claimant was responsible for the goods or services which they're being sold. And the misrepresentation doesn't need to be active. It could arise from the defendant's silence, a principle illustrated by the case of Law Society of England and Wales against Griffiths, and you don't need much imagination to work out what was probably happening there. Licensing and merchandising activities have been problematical for the courts in the past, partly because it's rather difficult to see where the misrepresentation might be. Old cases indicate that there had to be a common field of activity between the claimant or plaintiff and defendant. They had to be in the same area, the same sector. And certainly even now, where the parties share a common field of activity, certain activities will be easily characterised as passing off. So the old cases looking for a common field of activity were quite narrow. We have McCulloch and May, where a children's radio presenter sued a breakfast cereal producer because they were using his name in their advertising, and the court held quite easily that there was no passing off because they were in very different fields of activity. Harrods against the Herodian School, there was no passing off found there when the school opened in premises which had previously been the Harrods store staff sports club. There was no misrepresentation from that, that there was any connection between the two. Lyngstad against Anabas concerned the pop group ABBA suing a merchandise producer, something that we would now recognise, I think, as something which required a remedy, but in those days, back in the 1980s or 1970s, I think, the court said there was no passing off because they weren't engaged in the same field of activity. Nowadays, I think that boundary has probably evaporated, been knocked down. One case where passing off was held to be taking place was Lego against Lego and Lemon Stritch Limited, where of course the claimants were producers of plastic toy bricks, and the defendants, less well known, made garden hose attachments, so they're basically in the plastic moulding business, and on grounds which look very much like dilution grounds, a concept which is now found in registered trademark law. The court held that passing off was indeed taking place. So that diluted or reduced the value of the Lego trademark in the hands of the claimants. Their trademark was suffering some sort of damage, not damage resulting from direct competition, but a different form of damage, and therefore a remedy was given to them. If the parties are in different fields, generally speaking, the public must make a connection in their minds if there is going to be a successful passing off claim, and if there's a licensing agreement in place, the court may well infer that the public is going to make a connection. The Ninja Turtles case, Mirage Studios against Counterfeit Clothing, is probably the first case in the UK in which this relationship was recognised. There was no licensing agreement in place. In fact, Counterfeit Clothing had asked for a license from Mirage Studios, who owned the rights to the Ninja Turtles, and they'd been refused because there had been unsatisfactory business dealings between the parties in the past. So Mirage weren't inclined to enter into any licensing arrangements with them again. So they went off and got their own turtle designs made and printed on t-shirts, and they were sued not for copyright infringement because there was no copying taking place, but they were sued for passing off, and the court was able to apply passing off principles to this, what was then novel arrangement of character merchandising, and indeed followed quite a long line of Australian cases in coming to that conclusion. Then we got Stringfellow against McCain Foods, where Peter Stringfellow took action against McCain Foods, who were producing oven chips, which they were long, thin ones, and they called them Stringfellows, and he didn't like that, and convinced the court that the public would assume that some sort of licensing arrangement was involved in that. In order for there to be a deception, the defendant's actions have got to involve sufficient similarity between the get-up of their goods or the way they're promoting their goods, so that traders and the public think the goods and services are from the same source. There's no need to prove fraud. That's not an element. As I said, innocent activities can amount to passing off just as much as properly fraudulent ones. When it comes to proving that the public have been deceived, the courts have always preferred to see customers giving evidence in person. They're suspicious about surveys, because very often the survey can be tilted slightly by the way in which the questions are phrased, and certainly if you go to court wanting to rely on survey evidence, then you're going to have to ensure that the form of the survey is approved by the court and agreed by both parties before it's going to be admitted to the litigation. So the Neutrogena and Laboratoire Garnier case establishes that, or explains how it's necessary to have customers giving evidence in person rather than relying on survey evidence. And going back to the Jif Lemon case, when that was in the High Court, it took a couple of weeks for all the evidence to be heard. I think the parties had about 100 witnesses giving evidence about how confused they were, and also about how much they recognised the Jif Lemon container and how it embodied the reputation of the claimants in that case. The courts will look at things through the eyes of the common consuming public, but they will recognise that the common consuming public will vary from one type of product to another. So, for example, if they're buying pharmaceutical products, there's a good chance they're going to be nervous. If they're buying Jif Lemons, then there's a good chance they're going to be shopping in a hurry. In the Morning Star and Express newspapers case, the judge didn't test everything through the eyes of a moron in a hurry, but those words were used in the judgment. What the judge was saying, though, was that there is such a difference between the claimant's newspaper, the Morning Star, the Communist Party newspaper, and the Star, which had been launched by Express newspapers, was a red top tabloid. There were so many differences between them that he said not even a moron in a hurry will confuse the two. So modern case law tells us that the consumer is a reasonably well-informed, reasonably observant and circumspect individual, so subject to the requirements of the particular sector and the particular product, then that objective type of consumer is going to be the one that's invoked in the litigation. The third element, identified in the classical trinity, is damage. The claimant must have suffered, or be likely to suffer, damage or injury to his business or goodwill. And this might happen by loss of custom, it might arise because of confusion, it might arise because of injurious association, a principle beautifully illustrated in a case called Rolls-Royce against Dodd, where Mr. Dodd had built himself a motor car in which he'd put a Rolls-Royce Merlin engine, which he got the first one out of a Centurion tank, and he got the replacement one when that car got destroyed. He built another one. He got it from a Second World War Mosquito fighter bomber. So it had a Rolls-Royce engine in it. That didn't justify him putting a Rolls-Royce grille on the front and making it look as if it was a Rolls-Royce. And it looked so convincing that the German authorities used to write regularly to Rolls-Royce asking them not to test their new cars on the autobahn at high speeds. And it was Mr. Dodd driving off to rescue broken down motorists, which was what his business was, and he specialised in repairing Rolls-Royce transmissions, as it happened. So there was a further reason for him to have a connection with Rolls-Royce. It's a very fascinating and amusing case, but I think that's probably enough about it for the time being. The damage may arise from the loss of sales because of direct competition from the defendants, unfair competition, and passing off law is very much to do with unfair competition. It may arise from the fact that the defendant's goods are inferior. And there may also be dilution, as in the Lego case, where Lemel Stritch's garden hose fittings weren't in competition in any way, but they were damaging the value of the Lego trademark. Tattinger and Olbev, which is known as the Elderflower Champagne case, tells us that the damage doesn't need to be substantial. At first instance, the judge, Mr. Justice Hoffman as he then was, had decided that the elements of passing off were all made out. There could be people who would buy elderflower champagne thinking it substituted in some way for real champagne, but the amount of damage caused to the champagne houses would be minuscule. So he decided on that basis that the claimants didn't have a remedy. The Court of Appeal said, no, that's wrong. Damage doesn't have to be substantial. Even the smallest amount of damage or prospective damage is sufficient for the claimants to win. So a passing off action will lie where each of the plaintiff and the defendant are in trade. The plaintiff has established goodwill and the goodwill is damaged. It covers not just straightforward misrepresentations, use of what we would normally recognise as trademarks, but can also encompass slogans and visual images used in advertising, which becomes part of the goodwill of the product. That's illustrated by the pub squash case. It can protect geographical trademarks, Birmingham Vinegar against Powell, the Yorkshire Relish case, and Montgomery against Thompson, which was the Stone Ale case, beer made by a brewery in Stone in Staffordshire. In both of those cases, basically what the claimants were protecting were geographical names. It can cover the situation where the defendant is enabling other people to pass off their goods or services as those of somebody else's, rather than passing off directly. The defendant might supply goods to someone who then passes them off as somebody else's goods, for example. And this could happen where the customers are not very expert and don't recognise what it is that they're buying. In that situation, the manufacturer who originally applied the misleading get-up will be liable. John Walker and Sons against Henry Ost is the classic case here, where Scotch whisky was involved. It was distilled in Scotland, but it was sold as blended Scotch whisky, and it hadn't been blended in Scotland. So the passing off actually, well, the end passing off took place overseas, but of course no action could be brought for that because it was outside the jurisdiction. So the action was brought on the basis that the defendant was enabling other people overseas to pass the product off. Marks and Spencer's against 1 in a Million involves domain names. It was really the first case that came before the courts on domain names, and actually it's still the last important one. It went all the way to the House of Lords, and was decided on the basis, as far as passing off was concerned, that a domain name could be an instrument of fraud. The defendants argued that they'd registered all these domain names which alluded to people like Marks and Spencer's and Virgin and Ladbrokes, well, a long list of blue chip companies. And the defendant's business was to register these domain names and then offer them to what you would regard as the rightful owners, and say, well, you'd like to buy these from us because if you don't buy them, somebody else will buy them, and we don't know what they're going to do. We have no intention of pretending to be you, but the people who buy them from us might do. We can't tell. So the court said that makes them an instrument of fraud. Somebody who wishes to carry on some sort of fraudulent activity, pretending to be Marks and Spencer's, could get a domain name from 1 in a Million, and they'd be able to succeed with their misrepresentations to the public. So on that basis, 1 in a Million were held to be passing off as well. In the classical passing off situation, the defendant persuades the claimant's customers to give them their business. It can protect a number of different aspects of the business: personal names, for example, nicknames, trade names, and the get-up or trade name of the claimant's goods. The packaging of the goods, as in the Dolly Blue case, William Edge against Nichols. Packaging was also involved in Coombe against Scholl and Haig against Forth Blending involved the Haig dimple whiskey bottle shape. The Jif Lemon case, of course, I don't need to mention again, that involved the get-up of the goods in the form of the shape of the container. Colours and shapes can have a secondary meaning, illustrated by Hoffman LaRoche against Burke. The colouring of some pharmaceutical products can be very important. The pub squash case is a further instance of that sort of approach. Cadbury and Ulmer involved the shape of a chocolate bar, and Bostic against Sellotape involved the colour of the sticky putty. Those cases aren't entirely satisfactory, though, because most of them didn't succeed, and certainly Cadbury and Ulmer and the Bostic and Sellotape failed on the basis that the claimants failed to show that what they were trying to protect actually had trademark significance. In a classical passing off situation, the defendant may claim to be the manufacturer or supplier of the claimant's goods as well. Passing off claim can also deal with lookalikes, which is the case in the United Biscuits and Asda case, where a problem that manufacturers have been facing for a long time with supermarkets, that supermarkets had their lookalike ranges of products and manufacturers couldn't really do very much about it. The United Biscuits case is one of the few instances where the manufacturers actually succeeded. Finally, you can have advertising which damages the claimant, as in McDonald's against Burger King. It implied some sort of trade connection. It was a comparative advertising case, so the Burger King were comparing their product with McDonald's products in the advertising, but doing so in such a way as to suggest that there was some trade connection between the two, and that went too far and amounted to passing off. All these cases can, and very often do, also arise in the field of registered trademark law. As far as extended passing off is concerned, we're talking here about misusing a trade description that distinguishes another person's product, or taking advantage of a shared reputation of producers of that product, such as champagne, for example. It could be supplying goods or services in a way to suggest that the goods or services are sanctioned by the claimant, and the case on that point is Associated Newspapers against Insert Media, where advertisements were inserted in the newspapers without the consent of the newspaper publishers. Character merchandising falls under this head, and I've already mentioned the Ninja Turtles case, Mirage Studios against counterfeit clothing. And there'll be a little more in a moment on character merchandising. The quality of goods or services, rather than the source of the goods or services, can give rise to a misrepresentation and a passing off action on the extended basis, where it's not the source of goods but the quality that's involved. The Advocat case is a good example of that. Spalding and Gamage, the footballs case, where the defendant was selling second quality footballs, further illustrates that. Wilts United Dairies, which involved the sale of old stocks as if they were new, is also an illustration of that point. As for reverse passing off, the defendant claims that the claimant's product is theirs, rather than, as is the usual case, the defendant saying that their product is the claimant's, is illustrated by the case of Bristol Conservatories against Conservatories Custom Built Limited, where the defendant's salesman would visit prospective customers for conservatories, show them nice photographs of conservatories, giving the impression that these were conservatories that they'd built, whereas in fact it was the claimants who built them. So that's the other way round, normally, from the way passing off actions work. In character merchandising cases, the courts will generally look for four elements, for inferences that the public might draw. First of all, a licensing connection, and this was often where the early cases fell down, because there was a lack of a common field of activity and no developed sort of character merchandising licensing market for the public to latch onto. So in cases in the 1970s, such as the Wombles against Womble Skips, the ABBA case, Taverner Rutledge against Trexaparm, which was the Kojak Pops case, where the TV detective was commonly seen sucking on a lollipop, but didn't authorise Trexaparm to make lollipops and use that name to promote them. Back in those days, the public wouldn't assume that there was a licensing connection. Since then, things have changed, and now the Ninja Turtles case indicates that the public can be assumed to be well aware of the sort of relationship that exists between a licensor and a licensee. The court will also look for a suggestion that there is some sort of quality control, that the trademark owner exercises control over the quality of the defendant's products. They'll look for any indication of the origin or quality of the goods made by the defendant, and of course they'll also look for damage. Celebrity endorsement is a new development in the passing off field, where celebrities whose images or names are used without their authority to promote other people's goods may rely on passing off, and the key case here where this all started was Irvine against TalkSport, where the Formula One driver Eddie Irvine took action against the sports radio station who had printed a picture of him in their publicity material holding a radio to his ear, apparently listening to TalkSport, and he hadn't given consent to that. The judge at first instance, Mr. Justice Laddie, said this looks very much like a passing off case. We've never seen one quite like this before, but it falls neatly within the passing off formula, and he awarded Eddie Irvine damages of a couple of £1,000. But on the basis that he rejected an offer of £5,000, he was then hammered on costs, so he was going to have to pay the costs of both parties as a result of that decision. So there was a good reason for him to appeal, apart from the fact that he didn't think £2,000 was enough in any case. So they went to the Court of Appeal, and his counsel said, my client doesn't get out of bed for less than £10,000, very memorable phrase, and the Court of Appeal decided that £25,000 was a more reasonable amount of damages to be awarded. The important thing there, though, is that it establishes that celebrity endorsements, or false celebrity endorsements, are truly a matter for passing off. The essence of the passing off action then is some sort of deception of the public resulting from a misrepresentation. The deception doesn't have to be deliberate. The public might become deceived as a result of confusion which has been sown in the marketplace, so it doesn't require the defendant to go out with the intention of deceiving anybody. It might just arise from confusion which then develops into deception. It remains only to talk about the possible defences to a passing off action, which largely turn on factual situations. So if one of the elements of the classical trinity is missing, that there's no reputation or no misrepresentation, then a passing off action wouldn't lie at all. If there's no damage to goodwill, as in the Elderflower Champagne case, certainly at first instance, again, no passing off action would lie. Autumn against CBS indicates that there may be honest concurrent use. That could be a defence to a passing off action, and it's still possible that you'd be able to get by arguing that there is no common field of activity, a principle or defence which is well illustrated by the case of Annabelle's against Shock, which is a nightclub against escort agency, and you can quite see why the nightclub might want to take action for passing off in a situation like that. Well, that's passing off in a nutshell. There's a great deal more to be said about it, and because this is all judge-made law, there are many cases to look at, but this is not the time to go into them in detail. That's the basics that you need to know about passing off law, and it'll set you off to learn the rest of it.